And Mr. Rudolph, if you can please state your name for the record.
David Dante Rudolph.
All right, thank you. Okay, today is the date scheduled for a jail review. Your client was sentenced in May of 2023 for disorderly conduct as assaulting and resisting an officer was dismissed. And he was sentenced to probation and 30 days on the alcohol tether. He was permitted to travel to Virginia for a funeral. Upon his return, there was a probation violation whereby he pled guilty on June 21st. The court sentenced Mr. Rudolph to 5 days jail, suspended that jail pending a jail review on August 28th. On August 21st, we held the jail review and adjourned it to October.
This case starts off calm, almost routine, but don't let that fool you. What you're about to witness is a courtroom hearing that slowly spirals into a raw, emotional, and volatile exchange between a judge who's trying to maintain order and a defendant who feels completely fed up with the system. At the center of it all is David Rudolph, a man technically here for a simple jail review tied to probation, but emotionally he's carrying years of resentment, distrust, and unresolved anger. What begins as a procedural check-in turns into a full-blown outburst involving politics, military service, constitutional rights, and accusations of injustice. This is one of those hearings where the legal issue itself is minor, but the behavior becomes the real story. You'll see patience from the bench, repeated attempts to de-escalate, and a defendant who seems determined to push every boundary possible.
October 23rd, whereby we were at the Court to Schools program, so we thought it appropriate to set it for today's date instead of the Court to Schools program. And so today is the date scheduled for the jail review. And Mr. Shunke?
Your Honor, I've had an opportunity to review the jail review. I saw the recommendations. I'd ask they be adopted. Nothing further from the defense.
And so, Mr. Rudolph, did you go test on October 19th as Ms. Shaw had instructed you to do?
Your Honor, it was an oversight. The first thing I do every morning when I wake up is check whether I have to report or not, because I have to plan, because I don't drive for obvious reasons. It was an oversight. I
understand
tested,
that. And that was
the one.
Excuse me, please, just one moment. I
All right,
understand that October 17th was an oversight. I understand that, sir, which is why Ms. Shaw advised you to test on October 19th. Did you go test on October 19th?
Yes, in Lincoln Park on 4th Street.
Okay.
I filled out the paperwork accordingly. If you don't have it, it's not my fault. I have a receipt. I paid $25 to pee in a bottle.
Sir, I didn't say I didn't have it. I'm just trying to make a record. So I was asking if you went to test on October 19th.
All right. Was it negative or positive? Oh, Jesus. That's a problem.
What's the problem, sir?
What are the test results?
I'm looking in the file, sir.
I'm sure they're negative, as all of them have been. Your Honor, I respectfully want to address the court. I left my house at the age of 17 to join the military.
Right here is where the court makes something very clear. This is not a new case, and this isn't a surprise hearing. Mr. Rudolph has already been sentenced, already violated probation once, and already received leniency in the form of suspended jail time. This jail review exists for one reason: to decide whether that suspended sentence should now be enforced. That's an important distinction. The judge isn't here to punish him emotionally or politically, She's here to determine compliance. And notice how the defense immediately asks the court to adopt the probation recommendations. That tells you something.
To join the military police corps, because I love law, I love order. But what is going on in this country is the gross misconduct of justice. I respectfully ask you to release me from probation. I'll pay my fines, and I'm done with this circus. And it's not on you, it's not on the court. It's if my last name was Biden, I wouldn't be drunk in front of this court. Everyone knows it. If my last name is Trump, I'd be on a cross, crucified. And that's the only person that cares about this country. Because the Democrats and half the Republicans want to roll this country under the ground. And I've seen too many brothers and sisters die for this. And that's all I have to say. Whatever you want to do to me, I don't care. I can. What's the balance of my? I'm not asking you to do it, but I've done it plus 10. I did 8 years in the military, and 100 days in jail doesn't mean crap to me.
Well, I appreciate your restraint in choosing your words carefully. And to answer your question, sir, your test was negative. And
thank you.
The court.
It usually means the paperwork looks clean, or at least clean enough to avoid jail for now. But the margin for error here is razor thin. A single missed test, a single compliance issue, and suddenly that suspended time becomes very real. This hearing may sound procedural, but it carries serious consequences, and Mr. Rudolph's attitude is about to matter just as much as his test results.
Please let me go. That's all I want. I won't step foot in line anymore. I'll pay you the couple $100 I owe you. Please leave me alone. That's all I ask. That's why I live in Monroe. Because I don't want to see anyone. I don't want to deal with anyone. That's why I have 3 acres.
I can respect that. However, sir,
thank you. All right.
There is still a job that I have to do. And so the court had originally sentenced you to 18 months probation. You're eligible for early discharge. So you have a few more months to go if there aren't any violations within the next few months for you to request early discharge.
Ma'am, with all due respect,
yes.
that's not acceptable.
No, it's not acceptable?
No, it's not.
Okay.
I've earned the right to do what I want to do. And so what's the balance? So if I don't comply, what's going to happen? Oh, this is the part where my lawyer should speak up. My court-appointed lawyer, even though I paid $5,000 for Longton to represent me, and then he drops me because he's a shill. Shepke, got anything to say? Yeah, raise your eyebrows.
Nothing on behalf of the defense. Obviously,
do?
Mr. Rudolph has made his statements, and I still respectfully request that jail not be imposed. Thank you, Judge.
This moment should have been the end of it, in the best possible way. No jail imposed. Review adjourned. Clear warning given. This is a win. But instead of taking it, Mr. Rudolph continues to argue tone, language, and constitutional rights. And that's where defendants often misunderstand the First Amendment. Free speech protects you from government punishment for your views. It does not entitle you to disrespect court staff or disrupt proceedings. Judges can regulate behavior in their courtroom, period. The judge here is firm but professional, reminding him that probation officers and staff are extensions of the court itself. This isn't about silencing him, it's about maintaining order. And when someone refuses to accept that distinction, the court's patience evaporates fast.
Thank you. Mr. Rudolph? You absolutely have the right to, behave as you want to behave within the confines of the law and within the confines of this court's order regarding probation based upon the events that occurred on March 18th, which is why you're in front of this court.
Oh, because,
Sir,
ma'am, I don't mean to,
excuse
I don't.
me. Mr. Rudolph, Mr.
right,
Rudolph,
so-
please. I allowed you to say your piece, so please
Yes, ma'am.
refrain from interrupting the court while I am speaking. With the exception of your use of alcohol on your trip that this court gave you permission to attend for a funeral for one of your comrades, if I recall correctly. Other than that, you haven't had any other violations. So the recommendation is for the jail review to be adjourned, to not impose the jail at this time. So that's what the court's going to do. I will also, sir, remind you that when you have your appointment with your probation officer, that is also an extension of the court. So appropriate behavior and language is expected.
I don't mean to.
Just one moment, please. Please let me finish.
I'm raising my hand like I'm in grade school. Go ahead, ma'am.
The communication that you have had with Ms. Shaw is less than stellar, and
This is where reality hits, and Mr. Rudolph does not like it. The judge explains that early discharge is possible, but not immediate. That's standard. Probation isn't a negotiation, it's a structured process. You don't get released simply because you're tired of it. You earn it through time and compliance. Instead of accepting that explanation, Mr. Rudolph pushes back hard. He frames probation as something he's earned the right to reject, which is legally incorrect. Probation isn't optional once imposed, it's a court order. His frustration is understandable, but his response is counterproductive. At this point, his own lawyer wisely stays brief, knowing that adding fuel could make things worse. The danger here isn't jail, it's escalation. And unfortunately, escalation is exactly where this is heading.
that cannot continue. The staff here do not need to be subjected to the language and types of communication that Ms. Shaw was subjected to.
I think I can get my
Yes,
hand
Mr.
on it.
Rudolph. Mr. Rudolph,
ma'am.
did you
Yes,
understand what? did
yes,
you
ma'am, I
understand
do.
everything I
Ad
said?
nauseum, that's Latin. I understand that. I'm very well educated. As
I
well
didn't
as.
say you weren't, sir.
All right. First Amendment. What? I can't speak what I have to speak? It's the First Amendment. It's the First Amendment of the Constitution. I don't care if she doesn't like the way I speak. I've earned the right to speak how I speak because I know when I'm getting effed. Thank you. I'll pay you the money. Leave me alone. I won't step foot in Wyandotte. This is ridiculous.
Sir,
You're going to make me a pariah. You're going to make me a pariah. And I'll do it. And I'll expose it. I don't care. You can't do anything to me that hasn't been taken from me. Do you understand that? Ma'am?
Sir,
That's it. I'm done. I ain't playing the game anymore. I'm not
Sir,
playing the
again.
game.
listen, I am not going to have you yelling and screaming at me.
I'm not yelling and screaming.